Thank you, Mr. Chairman. General Lynch, as you may recall, a woman working for the IRS named Lois Lerner was held in contempt by the Oversight and Government Reform Committee and the full House and referred to the Department of Justice under your predecessor. Do you recall that?
Certainly, I'm aware of the reports of that. Thank you, sir.
Speaking of those reports, the committee reviewed more than 1 million documents, did approximately 50 interviews, and produced a report. Are you familiar? Have you read that report?
I have not had occasion to read the committee's report, sir.
Well, the Senate Finance Committee released a bipartisan report in August of this year finding that the IRS abused conservative applicants for nonprofit status. I repeat, abused applicants. Did you read that report?
I've not had occasion to read that report, Congressman.
Well, the gentleman sitting behind you signed on your behalf about an 8-page report explaining to us why nothing went wrong legally at the IRS. Are you familiar with that letter to Congress?
Yes, I'm familiar with the letter that the department has provided to Congress on this matter, sir.
And in that case, you didn't just indicate that, in fact, no laws were broken. You indicated that it was just mismanagement and that you found no laws broken. Isn't that correct?
Actually, Congressman, I believe that our review found that the management of the process by which tax-exempt applications were handled at the IRS was characterized by mismanagement and inefficiency in numerous circumstances.
Right. So you found that there was an administrative problem, not a legal problem. Madam General, are you familiar with 2 U.S.C. 194?
I'm sorry, sir?
2 U.S.C. 194, and I'll refresh your memory. It states, the statute covering congressional contempt states that it shall be the duty of the relevant U.S. attorney to bring the matter before the grand jury. In the case of the referral of Lois Lerner for contempt, the U.S. attorney failed to comply with that law under your predecessor. Are you willing to comply with that law? Are you willing to have the current U.S. attorney comply with 2 U.S.C. 194, which very clearly says shall have the duty, not may, not can make an independent decision about whether or not that individual has done wrong or should be held in contempt? Will you comply with 2 U.S.C. 194 and instruct your U.S. attorney to bring that contempt before Congress?
Congressman,
before the grand jury.
Congressman, I believe that matter has been reviewed by the U.S. attorney at the time, and a prosecutorial decision was made.
Okay, again, 2 U.S.C. 194 states that it shall be the duty of the relevant U.S. attorney to bring before the grand jury. The U.S. attorney did not do so. Is it your opinion that shall do in a law passed by both houses of the Congress and signed by the President is a discretion?
Congressman, I believe that the matter was reviewed by the former U.S.
No, ma'am, I'm asking you for a decision. When something says that you or your employees shall do something, do you believe that that's discretion?
Sir, as I indicated, I believe that in the exercise of prosecutorial discretion, the matter was handled and resolved.
Okay. Well, then we simply disagree on what the meaning of shall is, and I guess for your purposes, shall and may in the thesaurus are synonyms. Is that correct? That shall and may are equally able to be decided by your choice? Now, I'm not trying to be argumentative, but you're telling me shall is something that has discretion. What part of discretion is in shall do? Shall is you will do, isn't it?
Congressman, in the exercise of prosecutorial discretion, that decision was made.
Okay, so you have no respect for laws passed if you don't like them. You think you have discretion when something says shall is what you're testifying to today. My question to you is, during your predecessor, the Committee on Oversight and others asked for a woman working for you, Ms. Boserman, and wanted to do a transcribed interview. At that time, the Department of Justice said she would not be made available because there was an ongoing investigation. Since you have now dismissed that investigation, are you prepared to make her available to committees for a transcribed interview?
Congressman, it's the practice of the department not to provide line attorneys for congressional testimony. We seek to provide the information that will help you in your oversight duties.
Mr. Conyers is still sitting here at the dais. Mr. Conyers very bravely took on the Bush administration, where relevant U.S. attorneys and case law effectively now is that in fact, if a committee of Congress wants somebody, it is not a discretion to say no. In the case of Harriet Myers, that was pretty well adjudicated, and Mr. Conyers, as chair, made it very clear that Congress has a right to have someone. Again, I'll ask you finally. Previously, the reason was not that you would not make a line attorney available, but Ms. Boserman was part of an ongoing investigation. Since that investigation is done, are you saying today that you refuse to have her available under any conditions?
I'm saying that I'm being consistent to the policy of the Department of Justice.
I'm not asking a policy question. I'm asking about one individual.
That would include that.
When there is no ongoing investigation, they would like to talk about a past investigation. If she is requested, will you make her available?
Congressman, as I've indicated, we provide information to the committee, and we seek to do so through a number of means. As indicated, we've provided a letter, and we are certainly happy to continue with our offer of a briefing to the full committee on this matter. With respect to line attorneys of any investigation, it is not the policy of the Department of Justice to have the line attorneys testify, because they do their work independently and focusing solely on the facts and the law, and we do not want them having to deal with the issue of a political review of their work. They are focused solely on the facts and the law, and they follow the evidence where it leads. As I've indicated with respect to the letter, and as I believe the previous Deputy Attorney General indicated, in this matter, we're happy to provide information to this committee, and I believe we have offered a briefing to members of the committee on the matter as well, and we do certainly stand by that offer.
Mr. Chairman, I appreciate the indulgence for her answer, as insufficient as it was.
Chair thanks the gentleman and recognizes the gentlewoman from the Inspector General Act, which is currently on the books, says that inspectors general, in carrying out their provisions under the Act, is authorized, and I quote, to have access to all records, reports, audits, reviews, documents, papers, recommendations, and other material available to the applicable establishment which relate to programs and operations with respect to which the Inspector General has responsibilities under the Act. Somehow the Office of Legal Counsel indicated on July 20th that despite longstanding tradition within the FBI, specifically, the Department of Justice Inspector General is no longer allowed access to grand jury testimony, wiretap information, credit information. We disagree with that conclusion, but at this point we have worked with the Inspector General, worked with this committee, and we're still waiting for full input from the Department of Justice to try to rectify this. I was hoping that I get some commitment from you to work with us and spend time with us on the proposed piece of legislation. I think the current law is sufficient, but you don't, and we're trying to come up with something that would rectify this. Would you be willing, as somebody from the Department of Justice, give us guidance and input on this?
Thank you, Congressman. I think that you certainly raised the important issue of the important work of all agencies, inspectors general, in particular the Department of Justice.
I just want to get a commitment that you'll work with us on this proposed piece.
We have sent legislation up. We feel that would clarify it and in fact ensure that the Inspector General would receive all the information he needed. And
would you meet with us, not you specifically, with somebody within the Department of Justice to give input on the piece of legislation that I'm drafting in a bipartisan way with Mr. Cummings to try to resolve this?
We're happy to meet with you.
Okay, and hopefully soon, I hope.
I will have my staff reach out to yours. We're happy to meet with you and work with you on that issue.
I've also had great concern on geolocation. In July, the Oversight Committee, we sent a letter seeking the so-called Jones memos. This relates to a Supreme Court case from a number of years ago. On October 26th, I did a bipartisan bicameral letter. 6 representatives, 5 senators, including the ranking member from both judiciary committees in the House and the Senate, calling on the Department of Justice to share with Congress these letters. I still don't understand why you won't share this information with us.
Well, certainly with respect to the request that you refer to the extent that it refers to the internal deliberative process of the department, we typically do not provide those specific memos. However, we certainly do look forward to working with you to share the information that...
You don't think that the House Judiciary Committee, the Senate Judiciary Committee should understand your approach in tracking people through geolocation?
We certainly are willing to sit and work with you to convey what we can, and as much as we can about...
That's a huge step forward, because thus far the Department of Justice has not been willing to share with us any information or have such meetings. So I look forward to that meeting. I need to ask one more topic. I'm trying to go quick just because of the time. Share with me your thoughts and perspectives on subpoenas. You know, subpoenas are often issued from a variety of different places, but Congress also issues subpoenas. Do you feel a duty and obligation to help enforce those subpoenas as well?
Certainly, that's part of the obligation of the Department of Justice in terms of its general law enforcement obligations.
When would you not enforce a subpoena?
You know, I would have to know more specific facts and context to provide an answer as to whether or not we would not be able to for some reason, or whether there would be a reason not to. I would have to have more...
Do you feel a duty and an obligation to enforce then a congressionally issued subpoena?
Certainly, with respect to a subpoena issued by any body, be it Congress or be it a court, the decision as to whether to enforce it or not would be one that we would review and determine the best course of action to take. But I would certainly like to have more facts about the specific issue, if I could.
I think what the gentleman is asking is a subpoena goes out and someone does not comply with the subpoena. How do you view the department's obligations to enforce compliance? A subpoena is only as good as your ability to enforce compliance, and we don't have access to a police force, which is a good thing. So we're relying upon you to enforce them, and I take the gentleman's question to be, how do you view your obligation to back up this branch of government when it needs access to documents or witnesses?
Again, Mr. Chairman, I certainly, with respect to a subpoena from this body or any other that would come to the Department of Justice for enforcement, we would review all the information about that. Certainly in my career as a prosecutor and as a U.S. attorney, I've had occasion to issue subpoenas and then work on alternate means of compliance, both as a prosecutor and as a private attorney. So there are a number of ways in which we can obtain compliance, and I would certainly need to know more of the factual predicate before I could provide you with any specific guidance.
Yes, ma'am. Gentleman yields back. The chair will now recognize the gentlelady McCallum. Now recognize himself. Madam Attorney General, I want to tell you I enjoyed visiting with you recently, and I want to thank you for Sally Yates' recent trip to South Carolina, which was very well received. There are three areas I want to cover with you. First would be Mr. Kadzik's letter to Congress recently, and I'm going to paraphrase one of the paragraphs, but it's a pretty close paraphrase. The IRS mishandled tax-exempt applications in a manner that disproportionately impacted conservative groups. I read that to mean that he found a discriminatory effect. In other words, there were similarly situated people, but there was a disparate impact on conservative groups. That's, I think, the only way to read that paragraph in Mr. Kadzik's letter. He then wrote, it left the appearance that the IRS conduct was motivated by political, discriminatory, corrupt, or other inappropriate motives. So you have a discriminatory effect, but he said the motive was mismanagement as opposed to a crime. And then that got me thinking, if my sheriff stopped only red cars for speeding, at what point is it not mismanagement, but it actually is circumstantial evidence of intent?
Well, with respect to the actions that you refer to, Congressman, I think you certainly are accurate when you indicate that our letter noted that the groups that had complained were treated differently from other groups, and they were also treated in a way that did not advance their applications. They were treated badly. So one can understand their concerns and the issues that they raised. With respect to the investigation, as we outline in our letter, under the relevant statutes that we were reviewing, we needed to find evidence of criminal intent. That intent was not there. With respect to the example that you raise, Certainly, there are certain statutes that take into effect a discriminatory impact, but again, even in our civil rights laws, if one had a discriminatory impact, you would not necessarily be able to prove a discriminatory intent.
It's really hard to prove intent, really hard, which is why usually you use circumstantial evidence. And if female voters were required to show 2 forms of ID, but male voters were only required to show 1, how many voters would have to pass through the prompter before you would say that's circumstantial evidence of an intent to discriminate? Never do you have direct evidence of intent. It's really hard to prove intent, which is why we typically use circumstantial evidence. And I noted in Mr. Kadzik's letter, he didn't say there was insufficient evidence. He said there was no evidence. But would you agree with me that there's a very big difference between saying insufficient evidence and absolutely no evidence, which is what he wrote. He found no evidence of any intent to discriminate, despite the fact that there's a discriminatory effect.
Well, I think the letter does speak for itself in that regard. What I would say is that, Congressman, as a general matter in how we handle our criminal investigations, we do look for evidence of intent, and it comes in a number of ways, some circumstantial, some direct. Every case is different. In every investigation, as in this investigation, we gather all the evidence, we gather all the facts, and we apply the law to those facts, and let that determine the answer.
I'm with you, Madam Attorney General, but you can see the discriminatory effect. So that's half of what you have to prove, and it's already there. You concede that. And we've got emails from Ms. Lerner that we need a plan, but we have to be cautious that it's not per se a political project. I think a jury would find that to be an interesting email. She worried mightily that a Republican control of the Senate might be tantamount to a Republican president, and she wasn't thrilled about that. That would be circumstantial evidence of a political motivation. She referred to the Tea Party as very dangerous. I mean, how many pieces of circumstantial evidence, keeping in mind the author of the letter didn't say insufficient. I could have lived with it if you'd said, look, our prosecutors just couldn't make the case. It's a close call, it's a jump ball, we couldn't make the case. That's not what he said. He said there's no evidence. I just cited 3 emails that I think would be evidence of some intent. Don't you think?
Well, Congressman, as I said, I think the letter in its full entirety speaks for itself and does outline not only all of the issues that you raised, but the host of other things that were reviewed and looked at in the course of the investigation, and does explain the conclusions to which the department came. With respect to the referral, the issue was whether or not there was evidence of a criminal intent. That is to say, did one act on certain views? Was that the reason for the actions? And as we've noted in our letter, and that we've offered to have in further briefings with you, we did not find evidence of that through the 1,000,000 pages of documents and hundreds of witnesses that were interviewed.
I would love to take you up on that offer for a private debriefing, because I need somebody to explain to me the difference between specific intent and general intent, because as I read her emails, even some of the mediocre prosecutors on this panel, I think, could get to a jury given the evidence that they have. I want to touch on 2 other issues, and then because there's a trend of going over, I would invite you at some point, and this is going to be a bipartisan comment, because this goes back to 2004. And 2004, there was a Republican administration. If you look at the firearms prosecutions from 2004 to 2012, you're going to be shocked at how few prosecutions there were, not for 924C, not for firearms offenses that happened during a crime of violence, but I mean lying and buying, selling a gun to somebody who's been adjudicated mentally ill, somebody who's been committed. There were 22 guilty adjudications over the course of 9 years for people possessing firearms who were users or addicts of drugs. 22 in 9 years. So when I hear my friend from Florida talk about the need for more gun laws, yes, we're going to say, how are you doing with the ones you currently have? And I would invite your attention to this chart, which came from former Attorney General Holder, provided it to us. I think you're going to be shocked at how few, and I get that there's not much jury appeal. Trust me, I get that it is hard to go in front of a jury in a lying and buying case. But you noted earlier the focus on firearms cases in the context of violent crime. And I think we would all agree the objective is to prevent the violent crime, not to do a really good job prosecuting it afterward, but to keep it from happening in the first place, which is why I would invite your attention to this. My last point is simply this. You have been asked repeatedly this morning to comment on ongoing investigations, and you always give the same answer. And it's the exact same answer that Marino gave me in the back, who's a former U.S. attorney, and it's the exact same answer Mr. Radcliffe gave me in the back, who's a former U.S. attorney, which is you can neither confirm nor deny the existence of an ongoing investigation, and if we happen to know about one, you're not going to comment on it. That's exactly what you should say. I'm just wondering why the president didn't get that memo. And you may, in your well of souls, believe that it does not impact Director Comey or you, and it may not, but I promise you it impacts the perception of my fellow citizens when the person who is responsible for executing the laws in this country prejudges the outcome of investigations. It may not impact the reality, I promise you it impacts the perception, and that's equally dangerous. And with that, I would recognize a gentleman from Illinois, Mr. Gutierrez.